Hello, and welcome to the Wiley Election Law Podcast. I'm Brandy Zaire, a partner in Wiley's Election Law Group. I'm joined today by Scott Delacour, a partner in Wiley's Telecommunications, Media, and Technology Group, and Boyd Garrett, an associate in the TMT Group as well. Today, we're going to discuss the Telephone Consumer Protection Act, also known as the TCPA, and how it relates to the 2020 election cycle. Before we jump in, I just want to remind our listeners that we're talking about a really complicated area of the law and that this podcast is for informational purposes. It is not legal advice, and organizations seeking advice on the TCPA should reach out to counsel. So with all of that out of the way, Scott, would you mind just explaining what the TCPA is?
Sure. Thanks, Brandy. The TCPA is a federal consumer protection statute that was enacted in 1991. There are a number of elements to the act, but the part that is the focus of most litigation and compliance efforts is the automatic telephone dialing, or ATDS, restriction. The TCPA prohibits calls to wireless numbers, and calls has been interpreted to mean both a telephone call and a text made by an automatic telephone dialing system. And you may be asking yourself, well, what is an ATDS? The term refers to a machine that automatically places phone calls. As we'll discuss later, the meaning of the term has generated significant litigation, much of which is still ongoing. The Act also prohibits calls that utilize pre-recorded voice messages, but there are some fairly broad exceptions to these prohibitions. For example, people can consent to calls covered by the TCPA, but that consent can be hard to obtain. The FCC has the rulemaking authority to interpret the TCPA, but the statute also allows for private parties to bring lawsuits for liquidated damage against violators. If someone calls or contacts you in a way that violates the TCPA, you can potentially be sued, and the damages run from $500 to $1,500 per call. So we're talking about fairly significant damages.
Got it. So certain calls are prohibited and violations can be remedied by either the FCC or private plaintiffs. And why does the TCPA matter for the 2020 election cycle?
Well, political campaigns are some of the biggest callers and texters out there, and the TCPA does apply to campaigns. In fact, both the Bernie Sanders primary campaign and the Trump campaign have faced class action lawsuits for text messages that they have sent this year. Political callers that are not TCPA compliant face significant risk from both the FCC and the private plaintiffs we talked about. With respect to class actions, the damage exposure can be enormous.
So Boyd, on that note, could you give us a sense of the regulatory risk from the TCPA? What in particular should political callers be worried about?
Sure. So Scott is absolutely right that the risk is significant. So first, on the FCC side, the Commission has said over and over again that robocalls are its #1 consumer protection priority. It's also engaged in significant rulemakings related to robocalls this year, many stemming from the passage of the TRACED Act, an anti-robocall statute that was signed into law at the end of 2019. In addition, the FCC proposed its largest fine ever, $225 million, for a Texas-based robocalling operation in June of this year. Now, to be sure, the Commission has largely focused on true bad actors. So these are people that are making fraudulent scam calls, but the FCC also cares about legitimate callers. In 2018, it even issued TCPA guidance specific to political callers. Then on the litigation side, the TCPA has generated thousands of class action lawsuits. In fact, FCC Chairman Ajit Pai wrote in 2015 that the TCPA was the, quote, poster child for lawsuit abuse, end quote. And Scott, in his previous advocacy on the TCPA, has documented some of the professional TCPA plaintiffs. These are people that maintain dozens of cell phones and intentionally farm robocalls to generate lawsuits. In terms of concrete numbers, the Chamber of Commerce released a study last year documenting more than 5,000 TCPA lawsuits over a 3-year period. And while this next figure I'm about to give changes from month to month, somewhere between 1/4 and 1/2 of all TCPA lawsuits filed are class action, which, like Scott said, brings enormous liability risk. So to sum up, businesses facing a TCPA lawsuit or enforcement action could be looking at many thousands or even millions of dollars in liability.
So I know there was a big TCPA Supreme Court case last term called Barr versus Association of Political Consultants that dealt specifically with political callers. Scott, can you tell us a little bit about that case?
Sure. Yeah, in that case, the political callers argued that the TCPA violated the First Amendment under a three-part argument. The first part of their argument was that the TCPA is ultimately a restriction on speech, essentially that the TCPA prohibits certain communications. Second, they argued that the restriction is content-based, meaning that the speech prohibitions turned on the content of the message being conveyed. Under the First Amendment, courts are more likely to strike down speech restrictions if they target certain messages. Here, the calling parties pointed to the government debt exception to the TCPA. This provision exempts calls from TCPA restrictions if the call is made for the purpose of collecting a debt owed or guaranteed to the United States. The plaintiffs took the position that it's one thing for the government to limit robocalls, but it crosses a line for the government to favor its own calls to collect its own debts over other protected speech. And the third part of the argument was that because there was this content-based distinction, that it required invalidation of the entire TCPA.
And what did the court make of these arguments?
Well, basically, the court bought 2 out of 3. The court agreed that the government debt exception violated the First Amendment because it discriminated based on the content of speech. But the court did not agree that this required striking down the entire TCPA. Instead, they found that the government debt exception was severable, meaning that this specific part of the statute was unconstitutional, but not the whole thing.
And why is that?
Well, we could really get into the weeds on severability, but at bottom, Justice Kavanaugh, who was writing for the majority, held that the question was governed by the Communications Act's severability clause. This is a provision that says that if one part of a law is constitutional, Congress intended that only for that provision to be stricken and not the rest of the law. So by Justice Kavanaugh's reasoning, this severability clause was dispositive and saved the remainder of the TCPA.
Got it. So the TCPA survived, and that decision appears to make it less likely that political campaigns will be able to rely on the First Amendment if they get in trouble under the TCPA in the future. Boyd, are there any other big TCPA litigation we should be watching?
Yes. So the Supreme Court this term took up another important TCPA question. So Scott previewed this earlier, but this case called DeGooid versus Facebook is a statutory interpretation issue about the definition of automatic telephone dialing system, or ATDS. So Scott mentioned one of the TCPA's key prohibitions is the prohibition on using ATDS to call or text people. So the definition of ATDS is central to the statute's functioning.
That does sound like an important case. What are the arguments for how to define ATDS?
So as with any Supreme Court case, the arguments are really complicated. And so for listeners that are interested in this issue, I just want to briefly pitch a blog post on Wiley Connect that I co-authored with several other CMC lawyers called Examining the Arguments Behind the TCPA Auto Dialer Circuit Split that the Supreme Court will consider next term. We take a super deep dive on this case and the underlying circuit split in that post, but this is kind of the more streamlined version, which is also still pretty complicated. So I'd like to start off by reading the TCPA's definition of ATDS, because it's really the key to this whole thing. So the TCPA says the ATDS is, quote, equipment which has the capacity, A, to store or produce telephone numbers to be called using a random or sequential number generator, and B, to dial such numbers. So the issue in DeGooid turns on that first clause, to store or produce telephone numbers to be called using a random or sequential number generator. There are 2 different ways to read that clause. The first is a narrow reading. That is, an ATDS includes devices that store numbers using a random or sequential number generator or produce numbers using a random or sequential number generator. So under that reading, equipment is not an ATDS unless it uses a random or sequential number generator in some way. The second reading is a broad one. That is, an ATDS includes a device that either stores numbers or it produces telephone numbers to be called using a random or sequential number generator. So under this broader reading, any machine that stores numbers could conceivably be an ATDS, even if it doesn't use a random or sequential number generator. So the question comes down to whether that using a random or sequential number generator clause modifies both parts of the statute or only the latter.
So why are these two different readings important? What is the practical significance of this definitional question for political callers?
Yeah, so although the underlying statutory arguments are kind of esoteric, the practical implications are really far-reaching for campaigns and really any entity making a large amount of calls and text. So as an example, imagine that the broad interpretation is the correct reading of the statute. Under that interpretation, ATDS includes any device that stores numbers, regardless of whether the device uses a random number generator. But that reading seems to capture basically every smartphone because a phone's list of contacts presumably stores phone numbers. For this reason, the DC 3rd, 7th, and 11th circuits have said that this interpretation has to be wrong because it sweeps millions of Americans within the purview of a statute that's supposed to tackle a pretty specific consumer protection issue. According to these circuits, a device has to use a random or sequential number generator. Otherwise, it's not an ATDS, period.
Got it. So the narrow reading avoids what seems to be a pretty anomalous outcome. What's the argument for the broader reading?
On the broader reading, the 2nd and 9th circuits, who split with those other courts, have relied on textual and structural arguments. So, for example, they point to the government debt exception. The one that Scott mentioned was declared unconstitutional in Barr. Their argument, which is pretty clever, is that the TCPA authorized the government to call people to collect government debts using an ATDS. However, they ask, how does that provision make any sense if an ATDS has to use a random or sequential number generator? It would seem weird to let the government call numbers at random until it reaches someone that happens to have a government debt. Accordingly, those courts say the better reading is that ATDS also includes equipment that simply stores numbers, even though that would seem to sweep in millions of smartphone users.
Yeah, I can see how this is a tough issue. Scott, what should political callers make of the DeGood versus Facebook case for this election cycle?
Well, organizations really have to decide what kind of risk they're willing to incur. But I think political callers should be aware that there is serious risk in this area. If the Supreme Court accepts this very broad reading, all kinds of devices could be swept up in the TCPA's definition of ATDS. Then organizations are looking at potentially massive damages on a per call or per text basis, 500 to 1,500 per call or text, like we talked about before. Campaigns, particularly national and statewide campaigns that will make thousands or tens of thousands of calls or send tens of thousands of texts, can do the math on that, and it's pretty scary.
While we're on the subject of ATDS, Scott, can you tell us a little bit about the FCC's recent clarification about peer-to-peer text messaging? I know that a lot of political callers are increasingly relying on peer-to-peer messaging.
Sure. In June, the Commission released a declaratory ruling that clarified that peer-to-peer, or P2P as it's sometimes called, text messaging platforms are not ATDS under the TCPA. For those unfamiliar with P2P platforms, the FCC was specifically talking about platforms that require active and affirmative manual dialing. According to the Commission, these platforms are not automatic telephone dialing systems because they require human intervention. This kind of begs the question of what active and affirmative manual dialing is. For example, does it include pushing a button that dials a single stored number? The Commission punted on this, essentially. I mean, they didn't answer the question, and they said they weren't going to get into the weeds about which P2P platforms were okay. So this is a helpful development and gives callers some flexibility, but there are definitely still some lingering questions out there.
Thanks, Scott. Well, to wrap up, I invite anyone who is interested in learning more about TCPA compliance to reach out to Wiley. Our attorneys in both election law and TMT follow these issues closely and are happy to help.